told that we're not supposed to be covering the actual case. Yeah.
You should walk. Two questions at least.
I was thinking of checking back where they had the press release yesterday.
Do you want me to stay here?
It's up to you.
Yeah, they said this is only
Hey, good morning, everyone. We're outside here, outside the courtroom, the courthouse, where the judge will decide on releasing the Bodycam footage. So the family and the attorneys just went in. I'm not sure how long this is going to take. I'd imagine it won't take very long. So once they get the decision, they'll come out here and just tell us. Hey, what's up? How you doing?
Good. You sleep all right?
No.
No?
Not at all. Hopefully tonight I will.
You're up editing all night? Or?
No, just have a couple stitches sometimes on the ships.
On their side too?
Yeah. I mean, especially like, sometimes you have the adrenaline rushing. It takes a while to get through my system, but, I get restless.
Nice. Some pictures took a while and by the time.
Yeah. Oh, nice.
I tried to read a book a little bit. There was no way. And I wouldn't think so. I don't know if it may take a while to get for the judge to make a decision. I don't know if the proceedings will take long. I don't know why he would hold it up. Families in it already, bits and pieces of it. I know it's
Hey everyone, don't forget, as soon as you come in here, please hit the like button. This way, more viewers, the stream will get to more viewers.
should have waited and started watching it later. I mean, I don't think it would take very long.
Are you live right now?
Yeah.
So after this, maybe around 11:30, there is going to be a march from one of the churches over here. Oh, yeah. Looks exactly like him.
Had it on. Oh, thinking I had it on.
So as everybody knows already, the FBI did open a civil rights investigation into Andrew Brown's murder, and they should be around here. Haven't seen any feds yet, but I'd imagine they'd be at the near Andrew's house where he was shot and killed. I went over there yesterday, grabbed some footage. There's a little memorial there for him. Spoke to some neighbors who were not at the scene. I mean, who were not there when it happened. Also, I spoke with a neighbor who was lived directly across the street from Andrew, and there was a bullet hole in their house. The front of the house went right through and hit a skillet in the kitchen. But thankfully they weren't home at the time. And then yesterday, not sure if you all saw, but police showed up in riot gear for, I don't know, maybe 20 protesters, 25. 7 of them were arrested for basically just not leaving because of the curfew. They were blocking the road. Also, they had blocked traffic. That bridge that goes into Camden County, I think it was Route 158. They had traffic backed up all the way to the Virginia, North Carolina state lines. So that was pretty major. Yeah, the 7 protesters who were arrested yesterday, I'm sure they're out.
So I was hired by Reuters and
I saw one of the protesters here today, so I'm pretty sure they all got out.
yeah, absolutely, yeah. I mean, at this point, he was already paid. Not bring any electronic devices.
Did you say we could check them in with you up front? I'm alone here. I don't have anybody I can leave it
You can
with.
check in your cell phone. Yeah, well, newspapers sort of segue into the
So I think some reporters here are going to go into the courthouse.
He was living in South Carolina.
Charleston. That's right.
If I do go into the building, I don't think I'll be able to stream. So I'll stay out here and keep the stream going. You guys are welcome to.
He was telling me when the hurricane comes, I got 70 windows.
Yeah,
17?
I don't know if they could bring their phone in to the courthouse.
It was a big house. I saw it. It was a big house.
So I'll wait out here.
I'm just yearning for like concrete targets. How do you power wash your property? I miss that. I lived in Singapore for 17 years. There's something to be said for not owning a yard. It made sense at a certain time in my life. I'm really ready to give it up.
Those apartment, condo living boards weren't so tutorial.
Are they difficult?
It can be. And then the whole idea of paying monthly fees, which are more than mortgages.
Oh, really?
Sometimes.
Oh, geez.
Because they're closing.
Well, that you're not gonna have to pay that regardless. But the other stuff. Wow, I need to get to Florida.
Well, we don't have state taxes.
That's good. I'm sure they make it for that.
This is
State taxes? No, it's pretty low tax. Maybe just the size of the economy is big. The economy would make enough.
Oh, so the march at 11:30, they're going to be marching from the church to the site where Andrew was killed.
starting soon. The lawyers went
And then I'm sure there will be things happening later. So make sure you text COUP to 370-370. You'll get the notifications when I'm going live.
Yeah, it is eventually. Always to do, didn't help with it, but I just came out. Right. It was not necessary. Okay. There's a march at 11:30, walking over to his house, to where the shooting took place. So I don't know do we want to babysit this thing? And should we? Is there anybody to?
I don't see. It's mostly media reporters here. I don't see any activists just yet. I'm sure they'll be gathering here soon. But the public safety building is right around the corner from here. It's usually where they're gathering. The public safety building is the police station. So an article came out early this morning, maybe about an hour ago. It came out. Pasquotank County, North Carolina, a judge could rule to order the release of the Bodycam footage in the Andrew Brown Jr. case on Wednesday. That's today. So lawyers for a coalition of media companies will go before the judge to ask Pasquotank County to release the Bodycam footage. Brown was shot and killed by deputies in Elizabeth City last week while they conducted a search warrant. As we know, we found out yesterday from the independent autopsy that he was shot 4 times in the right arm. That's from having his hands on the steering wheel. And then he was shot once in the back of the head. So a total of 5 shots. Yeah, his family and the attorneys have called this death an execution. Basically, it is an execution. Under North Carolina law, a judge has allowed the footage to be released to the public. Pasquotank Sheriff Tommy Wooten said in an exclusive interview on Wednesday that he will petition the court as well to release the video. Now, I'm not sure if you remember from yesterday and the day before that I spoke to some of the protesters who had the "Where's Wooten" signs. So Wooten is Tommy Wooten is the sheriff here in this county. Wooten said that if it were up to him, he would have released the full video as soon as investigators allowed. In a statement released Wednesday, the North Carolina State Bureau of Investigation indicated that it will leave the decision to local authorities. We deferred. This is a quote. We defer to the local authorities and the courts to make that determination, as guided by state law. The SBI supports transparency to the greatest extent possible, as we think this serves the interest of the family, the local community, and North Carolina as a whole. Yeah, so it says that the hearing is at 10 a.m., which was 15 minutes ago, but we're not allowed to be streamed live.
Yeah.
So that's why we're out here, and then some reporters are going to go inside.
Maybe there's a business opportunity there. We could, set up, think about everything we need and then put it together in a kit, ready to go. And, sell it around.
Well,
keep it into 10 kits.
well, nowadays, I mean, a delivery service, just stuff.
A reporter on Twitter stated that when they asked the Sheriff Wooten if this was an execution, the sheriff said that it would come out in the investigation. He also said he has spoken to the deputies involved briefly to offer words of encouragement, but not about the investigation.
Yeah, there's a lot.
So,
I'm just following up.
so now they're being told no media will be allowed in.
Are they deliberating already?
No,
They just said no media?
I believe no more media. I don't know whether some media went in already. Didn't think any had, so I don't know. Maybe some did game.
Okay.
I know NBC TV has going to be cool for everybody. So, there's definitely one media.
Media's involved.
They're actually bringing the suits.
The pool has disseminated it.
Is it final?
What's that?
He just said the pool is already disseminating. I guess they have a live feed out. But,
So there is a live feed from inside. Let me see.
Well, if they're actually live streaming it in public.
is it a video?
Yeah.
Can we watch it too?
There was like rules about when you could include a tweet, but I don't know what the rules of that. All right, guys. Don't crowd the door too much.
Yeah, the people back there asked me, you know what the link is? No, we don't know. We don't know yet.
Oh, this is good.
Each of these petitions, there are 4 possible outcomes. First, the disclosure of the videos to the parties entitled to disclosure by statute may happen. There could be a release, which means providing a copy of the videos to the parties that are entitled to have a copy of the video by statute. There could be a denial or renewal of the petitions, or there could be a delay in the release or disclosure. Each petition will be evaluated pursuant to the statutory authority granted to me to release or disclose, taking into account those factors and standards put in place by our General Assembly when GS 132-1.4a was passed. There will be no decision made based on political whims of elected officials. This court intends to follow the law, apply the law to the facts, and reach the appropriate conclusions.
We can't all crowd. Back up, sir.
Remind all counsel present of their obligations under the rules of professional responsibility promulgated by the State Bar. And I want to remind the spectators here, I know that all of you here are interested in this case. I know that this is a very emotional time for the family members. I'm sorry for your loss, and I know the pain. I can't imagine the pain you must be going through, but I want you to know that in a court of law, there's going to be decorum. Okay, there's not going to be any outbursts or any behavior that will take away from these proceedings. So if you don't think emotionally that you can handle these hearings and control your emotions, then I'm going to ask you to leave, because by staying here, you're indicating to me that you're going to be able to do so, and we're going to have an orderly hearing. All right. Now, the first case that we're going to deal with is 21 CVS 261. That's a petition of the Pasquotank County Sheriff's Department. And Mr. Cox, I'll hear from you, sir.
Thank you, Your Honor.
Can you go stand further down? We cannot crowd the front of this building like this.
All right, we'll try and get. I'm gonna try and get the feed on my phone here. So they're not letting any orders in.
Yeah, just shoot me an email or text.
Let me try and get the feed on mine. What was the
Hey, Amanda.
do you know who's streaming? No? The stream is on CNN? Hold on, guys. I'm trying to get the stream here.
All trying to get Mr.
No, none of it.
Evan, I have it.
Okay. Yeah, I'm just not listening, so I'm not crowding around someone else's phone. Oh, I appreciate it. Thank you.
Astrid, I gave you guys the wrong link. Here it is.
I mean, Brett and I are both on top.
Okay? Because it's not on the website, so it's a private feed for everybody. I don't know how I know that.
Can you tweet it? Is that allowed?
No, because it's private. It's just for media. Okay. Sorry, guys. I hurt my first day to the show. I didn't know what I was doing.
Thank you.
Sets forth a presumption against release at the outset of the statute. Disclosure, Your Honor, as Your Honor is well aware, disclosure is not the same as release. They're two different words and they're defined differently in this statute. The disclosure mechanism says, shall. This is the only mechanism by which law enforcement body cams can be disclosed. It is not a may, it's not a maybe, it's a shall. Then the statute begins to enumerate certain persons that are entitled to disclosure. Those enumerated persons, and I'll be really quick, an actual person whose image, likeness, or voice is on the video, a personal representative of such person, a personal representative of a minor or an adult who's under a guardianship, a personal representative of a deceased person whose image or likeness is on the video, and that's what we're dealing with here, or a personal representative of an incapacitated person. Your Honor, statute then moves down for the considerations that the law enforcement agency is to consider upon disclosure to one of these enumerated persons. Of course, that person has to have standing. It has to be one of the enumerated persons under the statute. Then the law enforcement custodian needs to consider whether the information is confidential. Does it contain information of a highly sensitive or a personal nature? Would releasing it cause harm to someone's reputation or jeopardize their safety? Would releasing be a serious threat to the fair, impartial, orderly administration of justice? And does confidentiality necessitate
All these
the
photographers
protection
crazy.
of an active criminal investigation?
Y'all care about what's
Those are the
happening or not?
factors for the individual law enforcement agency to work through as they're thinking about disclosing to an individual person. We're here for release, a petition for release. Once again, a petition for release can be filed by one of these persons who has standing that we've just enumerated, or by the law enforcement custodian, and that's what we're dealing with here, is we have a custodian petition. The sheriff has come forward and asking that this court release this video. Question number one, is the person to whom the sheriff would like to release the video, is that an enumerated person? If we answer that yes, then we go on. Your Honor then must consider 8 factors. Factor number 1, is it necessary to advance a compelling public interest? Factor number 2, is there information on the body cam that is confidential or possibly exempt from release? Does the camera have evidence that pertains or determines legal issues in another court proceeding? Once again, we get to the highly sensitive or information of a personal nature contained on the body cam video, or whether release would harm the reputation or jeopardize safety. Once again, whether release would cause a serious threat to the fair, impartial, orderly administration of justice. Your Honor must consider whether confidentiality is necessary to protect an active criminal investigation, and then finally, whether good cause is shown. If I can, Your Honor, I'd like to walk through a little bit of that. If Your Honor decides to release, obviously, question number 2, as Your Honor has stated, the 4 possibilities. How much to release? You're only to release the portions that are subject to the request, and then the court may place any conditions that the court deems appropriate upon such release. I am arguing, or at this point, reiterating the factors that I believe the court should take into consideration at this time. Number 1, a compelling public interest. Certainly, there's a compelling public interest of public accountability. There's also a compelling public interest of a fair trial. Release at this point, in my opinion, jeopardizes both of those. How can the citizens, how can the citizens of the 1st Judicial District have confidence in any decision that I make if they believe that I made it on the whims of public opinion? How can we conduct a fair trial if after release, potential jurors they will form and express opinions regarding what they've seen? And let's remember, what is on the body cam has not been subjected to the North Carolina Rules of Evidence. If we end up in a criminal trial, that's when release is appropriate within the confines of the North Carolina Rules of Evidence. Public interest for accountability is not the same thing as public interest to exert influence over decision makers. Whether release would jeopardize safety. Your Honor, I think the example of Mr. Mike Cox is probably the best example that we have. Mr. Cox had demonstrators at his home, at his personal residence, and he is simply tangentially, administratively connected to this case. He is not one of the subject officers of this case. I think it's easily determined by Your Honor that release at this point could jeopardize the safety of the subject officer. Judge, we get into the fair and impartial, orderly administration of justice. If I may take just a second. The district attorney has 2 roles. Everyone knows that one of the roles of the district attorney is to prosecute criminal cases, prosecute potential criminal defendants for actions that occur within that person's judicial district. Of course, everybody understands that to be my job. The other role of the district attorney is to protect the integrity of all cases. Your Honor, it is my job to ensure the fair, orderly, impartial administration of justice. And that includes protecting a potential defendant's right to a fair trial. It is the exact same thing I did in State versus Brady, the Pasquotank prison murders, where we did not release any of the hours of video footage or body cam footage that we had of that tragic event. We waited until we could release pursuant to the North Carolina Rules of Evidence in a court of law at a trial of the matter. Your Honor, if that's where we end up, that's where the release needs to be. I also believe that to be the most important role of the district attorney, protecting the orderly administration of justice. Your Honor, you must consider whether it's necessary to protect an active investigation. There is an active investigation.
Your Honor is acutely aware that there is an accurate and independent investigation being performed by the North Carolina State Bureau of Investigations, which is an independent third-party agency of the Pasquotank Sheriff's Department. They're going to do a thorough job, Your Honor. We know that they are. That job, the public needs to believe that that was done free from any bias or influence by any public officials, any actors, the court of public opinion. Your Honor, we're still hearing from witnesses. Release at this time would jeopardize credibility of those witnesses. As Your Honor is well aware, law enforcement, one of the foundational principles of law enforcement is always to hold back some potential information of a criminal investigation so you can determine whether when someone comes forward, if they know this particular piece of information that hasn't been released, you know that that person is credible. You know that they were an actual eyewitness. We need to protect the ability of the witnesses to tell a credible story. Second, once released, if anyone is involved, I believe it will quell cooperation. Everyone needs to have an opportunity to tell what they saw, what transpired on that day. Your Honor, that takes us to good cause. Your Honor must find that there's good cause to release. The best good cause that I could come up with was humanity, care, and dignity for the family of Andrew Brown, Jr. The family of Andrew Brown, Jr. has demonstrated humanity and care and dignity in their actions thus far. They deserve no less from those of us in our positions. They deserve no less than that from the district attorney. I believe that to be a compelling interest. So, how do we do that? How do we fulfill that obligation to the family of Andrew Brown Jr. and also fulfill our statutory obligations? My oath of office that I will perform my duties without fear, favor, reward, or hope of reward. An oath I take very seriously. So how do we accomplish that, Your Honor? Well, I would ask that Your Honor conduct an in-camera review of all 4 body cams. I know, Your Honor, to be very well prepared. I don't presuppose how much Your Honor has seen of any of the body cams at this point.
Well, I'll tell you for the record that to the extent footage exists in the custody of the SBI, I have viewed it in camera and have reviewed it. I spent hours last night through it, so I have already viewed the videos and am aware of what the contents of them.
As I earlier stated, I know that Your Honor is always well prepared for any hearing that comes before Your Honor. If you, as you have, conduct an in-camera review of the 4 body cams, Your Honor, I would ask that you disclose immediately any portion of those 4 body cams that Your Honor deems appropriate to the request of the petitioner, to the family of Andrew Brown. I'd ask that you do that as soon as practical. If there needs to be any redactions that Your Honor believes need to be made, allow time to do that. But disclose whatever Your Honor decides needs to be disclosed to the family of Andrew Brown Jr. or their personal representative. That is disclosure. Your Honor, as far as release, I would ask that Your Honor release the video to the family of Andrew Brown Jr. I'm asking Your Honor to release the video in 30 days. I have been meeting every day, constantly, with the SBI. I am putting them under an incredible time crunch by asking this request for them to be finished in 30 days. I feel very comfortable that they can do that.
That's gonna run out at some point.
So what I would do is ask Your Honor to release the video, but delay that release for 30 days to allow the SBI to complete the investigation. Bring me all the blue paper that they have, all the videos, all the witness statements, all the ballistics, all the pictures. I will be ready to make a decision. In this order, Your Honor, I would ask that the delay of 30 days, if I come back to Your Honor and ask that you not release at the expiration of 30 days, it'd be only because of the change of circumstances. And everybody says, what is the change of circumstances? Well, Your Honor, if my decision at the conclusion of this SBI investigation is that criminal charges should be brought, then I'm going to ask Your Honor not to release the video. And it gets released in a court of law pursuant to the North Carolina Rules of Evidence. Let me say, I am committed to the disclosure and release of the video to the family of Andrew Brown Jr. pursuant to the rules of law. And it needs to be done one of two ways. It either needs to be released in open court at a jury trial after charges have been brought, or at a press conference held by me where I will release it. I will release all the facts, all my conclusions. I will answer all questions because I've made a no charging decision. One of two ways, Your Honor. There's one more matter, and that has to do with extrajudicial statements that have been made. If this is the appropriate time, I'll continue.
I'll hear from you.
Thank you, Your Honor. As Your Honor is well aware, we are governed by the professional rules of conduct. In particular, attorneys under 3.6, litigants in a proceeding, and there is a special provision for prosecutors, Rule 3.8. This deals with extrajudicial comments that are made by licensed attorneys who are involved in a proceeding, is what the rules say. And it's any public communication that has a substantial likelihood of materially prejudicing a proceeding. Any public communication. And we have had that in this case, Your Honor. A personal representative, Ms. Chantel Cherry Lasser, made comments to an open mic. They were public comments. She knew they would be broadcast. They were designed to prejudice a proceeding. If they were not, she knew a substantial likelihood that they should be. And on top of that, they were patently false. In her comments, she attempted to describe the movements of the vehicle being occupied by Andrew Brown on April 21st, 2021 at 8:30 in the morning when he was approached by law enforcement officers. She described those movements and then what occurred. Your Honor, in order to set the record straight, I believe that Your Honor needs to know those statements, when I say they were patently false. The video, the body cam video clearly shows Mr. Brown's car in a stationary position when approached by law enforcement, and they begin to shout commands. The car is still stationary when law enforcement officers grab the door handle, still shouting commands. The car goes in a reverse position. The law enforcement officer is forced to release the door handle, and the car is backing up. Those were the comments made by Ms. Cherry last. The car backing up, those movements. The car then stops. It is stationary once again. As it backs up, it does make contact with law enforcement officers. At this point, the car is stationary. There is no movement, and officers are positioned around the car. The next movement of the car is forward. It is in the direction of law enforcement and makes contact with law enforcement. It is then and only then that you hear shots. I think that record, and once again, Your Honor, if I have said anything that is inaccurate, Your Honor has stated you have seen the video. Please correct me on the record. That is a fair and accurate depiction of the movements of Andrew Brown's car on that morning. I would ask, Your Honor, to admonish all attorneys in this case that this court will not put up with extrajudicial comments in violation of Rule 3.6 or 3.8 as it pertains to me. Thank you, Your Honor.
All right, Mr. Williams, would you like to be heard on behalf of of your clients?
Yes, Your Honor. For the record, my name is H.P. Williams, an attorney practicing here in Elizabeth City. I'm speaking on behalf of several other attorneys and their clients, all of whom wish to remain unnamed because of safety concerns. I am making a limited appearance for this hearing, and for this hearing only. Those I speak for, and I want to state that for this hearing only, I speak for those people, and we waive all
the family to get him in 30 days, or us?
related to
He said
this
hold it for
hearing,
30 days.
including
That's
the
when
lack
he's going to make a
of
decision about whether or not to charge people.
The court will note for the record your limited.
I'm a little confused because I thought he wanted to disclose to the family as soon as they wanted.
Yeah.
If he says that it's appropriate.
Should these issues arise later,
He hadn't decided if he gonna charge it.
Yeah.
Oh, okay.
and on their behalf, I consent to the hearing being held at this time. The court will further note your reservation of rights to raise these issues at a later time. Thank you, Your Honor. You know, on behalf of those lawyers and their clients, we feel that release of this information should be denied. Mr. Womble has made a good point regarding the difference between disclosure and release. Speaking for myself and my client, we would not oppose disclosure, but I think they are entitled to disclosure if the faces of the officers involved are redacted. There have already been threats made and attempts to identify who officers may be or may not be. And we would request that there be a redaction so that officers cannot be identified. With regards to the release, we oppose the release even beyond Mr. Womble, but I understand his point of view. We don't believe that release is necessary and that there is no compelling public interest. You know, there's a difference between the public wanting to see the body cams and the public needing to receive the body cams, and we do not see there is a need, especially at this point, for the public to see it. We're also, you know, as
There is a period of time now that an investigation is going forward. There is a possibility of a trial, and the public interest has to give way to the rights of possibly persons that may be accused, and therefore the delay, if there is a delay, if there is a release, needs to be delayed. You know, one of the things that is of greatest concern is the fear of the release causing a tremendous amount of influence being put on grand jurors, court personnel. As we've seen in the media over the last several months, the exertion is tremendous. And if you read what's on social media, they don't care what the truth is. They just want to put out there what they want it to be and try to exert influence on people that may be involved in this system. The recording contains information that is exempt from disclosure. Of course, we know that it's not a public record, and that it should not be released, and that if in fact there were to be some type of criminal prosecution, that it would be released in front of the jury at that time. The release would reveal information regarding a person that is of a highly sensitive or personal nature. You know, the death threats that are already being made, the threats against Mr. Cox and against other individuals show that if you were to release it, people would try to figure out who's who. And suppose they figure out the wrong person. What could happen to the wrong person? Your Honor, the recordings show images and voices of several law enforcement officers, and they could use those voices to try to identify who they are. The release may harm the reputation. You know, there may be somebody in there who has done nothing, but their reputation may be ruined. We know that the grand jury proceedings remain confidential, remain secret, because you don't want to ruin the reputation of a person involved, especially if there are no charges brought or no true bill returned. Likewise, to release these body camera videos could ruin the reputation of someone whose image may appear on there. And we know that release would create a serious threat to the fair and impartial and orderly administration of justice. It would threaten, if in fact a decision was made to charge someone, then where could you have a trial? You know, the national media is picking up. Where are you going to have a trial? There is nowhere that you would be able to have a fair and impartial trial for the people that may possibly be charged. They are entitled and have a right to a fair and impartial trial, and I believe this right to a fair and impartial trial trumps almost any other right that the Constitution gives us. There is no good cause, and there's been no good cause shown for the release of these recordings. And we would say, Your Honor, that we object to the release. However, I understand where Mr. Womble is coming from. So if, in fact, the court were to decide to release cameras, we would ask that you respect his request for there be a 30-day delay to complete the investigation. And we understand that if criminal charges are brought, we would join in his petition to the court to not release him at the end of the 30 days because the criminal trial would be the time to release him. If he were to make the decision to not institute charges, then we also understand that at that point, at some point they're going to be released, whether it's at a trial or at the time that he says there will be no criminal charges. So we understand that we would probably not have standing to object at that time. We'd have standing to object, but probably would not object if there is a decision that would be no criminal charges. However, I must mention something else, and that is I've heard on the news that MSNBC is announcing that there may be some federal investigation, civil rights investigation. And so if in fact that's true, then we probably will object to the release as long as that investigation is going on as well. Your Honor, I thank you for hearing me. The officers are very distraught over what happened. They feel for the family of Andrew Brown. But as Mr. Womble described to you, we believe that the shooting was justified.
Thanks, sir. All right, anyone else needs to be heard with regard to this first petition?
CBS is streaming.
I think I've got everybody.
CBS is broadcasting somehow.
All right. Mr. Williams, I meant to ask you before you walked away. Your waiver of notice and reservation of rights with regard to that, does that extend to the second petition?
Yeah, CBS is broadcasting on their website. CBS 17, yeah.
Yes,
CBS 17 is broadcasting. Yeah.
Okay. All right. I just wanted to make sure that I clarified that before we went forward, because I know you had some concerns about notice.
Oh, whoops, I'm sorry.
Okay. Thank you, sir. All right. I think what I'm going to do is I'm going to hear the other petition as well. I'll let everybody respond, and then I'm going to take them both and consider my decision. I'm going to render my decision this morning, but I'm going to do it at one time. So I'd like to, at this point in time, hear Mr. Toddy's petition on behalf of the media petitioners. And this is 21 CVS 262. And I've just called it, there's a number of petitioners, I've just called it the media petitions.
Thanks, man.
Ready when you are.
May it please the court. My name is Mike Toddy from the law firm of Stevens, Martin, Vaughn, and Toddy. And I'm here with my longtime partner. Only ever practiced law with all the purposes of practicing law. This is
Ready when you are.
May it please the court. My name is Mike Toddy from the law firm of Stevens, Martin, Vaughn, and Toddy. And I'm here with my longtime partner, but a person that I've only ever practiced law with since the first day I started practicing law. This is Amanda Martin. Ms. Martin is the longtime general counsel of the North Carolina Press Association and teaches media law at both the journalism school and at times the law school in Chapel Hill. I'd like to say I'm here with my lawyer this morning. Your Honor, as you remarked, we are here on behalf of now 20 media entities, which are the companies, as far as media outlets go, I believe I've lost count. It's a lot more than 20. We are here under 132-1.4a seeking the release of the recordings of the incident involving Mr. Brown from the time they began to the time that the protests that were spontaneous afterwards were that evening. That's what we've requested. Your Honor, the eyes of Elizabeth City, Pasquotank County, North Carolina, our nation, and perhaps the world are upon us today. The petitioners are not here to indict or vindicate law enforcement, and they are not here to indict or vindicate Mr. Brown. They are here in the interest of advocating for transparency in the hopes of aiding the national conversation we find ourselves in about citizens' interaction with the police. Your Honor, if I may, I'd like to give you a little bit of procedural background because I believe there's been some consternation about that, talk about the factual background, and then talk about our arguments in favor of release. Is that all right, Your Honor?
Yes, sir.
Your Honor, the petitioners, the original petition, and I will say there have been three, and I can delineate, was on behalf of a smaller subset of the petitioners that are before you today. We attempted to file that petition last Friday. The courier service that we used to bring it to Pasquotank County was met with the unexpected closure of the clerk's office, and it could not be filed at that time. I personally attempted to locate Chief Resident Superior Court Judge Tillett to see if he would accept the filing. He and I had a conversation on Saturday evening where he indicated that he would prefer we file it on Monday morning. It was here in Elizabeth City, and that's what we intended to do. It occurred to us, based on, as Your Honor is aware, this is a quite evolving matter, that there were also static cameras mounted on poles here in Elizabeth City. And so our original petition went to the sheriffs in Pasquotank, Perquimans, and Dare County, and the North Carolina SBI. With our amended petition, the first one was filed at 10:45 a.m. on Monday. Our amended petition was filed at 10:47 a.m. on Monday, added Elizabeth City Police Department, and we served all of those petitions. Actually, we served the one we tried to file on Friday on Friday via email and fax the best we could, and then we served the other one on Monday right after it was filed. Later that evening, we got an order signed by Judge Tillett referencing the respondents to the amended petition, which included Elizabeth City, ordering them to produce the recordings for in-camera review. It did not set a person or place or time, but it did have that order, and it also set the notice of hearing for this time that we're here this morning, and it ordered law enforcement to notify law enforcement whose image or voice appeared in the recordings to notify them of this hearing and their right to be here today. I believe this is the 33rd or 34th one of these I've done, and we always seem to get a little hiccup in that step, in that I don't have control over what service is done on law enforcement because I don't know who's in the video, and so that's where it becomes a problem. I think there has been a lot of unfamiliarity with the law, and part of what my mantra has been always is we've known from the very start that it would take an order of a Superior Court judge to obtain release, and we've not wavered from that. We get this process. In any event, Your Honor,
did you find, was the request for the poll camera that was produced for you, was that produced to you as well by the chief of police?
I'm not sure that I'm following you.
There was a video that was released outside of the appropriate procedures that was reported to have been provided to a media outlet that was on the internet yesterday. Was that released pursuant to a petition you filed?
Your Honor, I don't know why it was released. Here's my understanding. It was unclear to me. I looked at the coverage of the first petitioner, the Daily Advance from last year, and indicated that the Elizabeth City security cameras were put up at the request of the police and were operated on behalf of the police. That's the last information I have about those cameras. It is my understanding, and so they fall into one of two categories. If they are operated on behalf of the police or by the police or law enforcement, then I believe they are under the statute. Alternatively, if they're operated by the park department or some other department, they would be public records under the law. My advice in any of those situations, if you don't know, are these operated by the police or not, because people aren't saying, and the police are not obligated to answer questions like that, make your public records requests, but we're going to make the petition in case they are law enforcement recordings. It's my understanding that they were released pursuant to public records requests. So in standing in front of you, I don't know Elizabeth City's position on whether these are law enforcement recordings or not. Based on my information from the Daily Advance from a little over a year ago, I thought they were. To answer your question specifically, I did not receive a copy. I saw them on the internet as well. I saw a video on the internet, and I believe I've only seen one.
I think there was one. Thank you.
In response to service of the amended petition, Mr. High contacted me on behalf of the Perquimans County Sheriff and he made an appearance and indicated that they do not have body cameras, and so there was nothing to be had. And I certainly told Mr. High that I understood and I would be happy to represent that to the court. And Mr. High appeared here this morning out of an abundance of caution. Similarly, counsel for Dare County contacted me and indicated, I talked with Ripley LeGrand first, and then his partner contacted me in writing and gave a letter, which I believe the court has, that they also don't have any responsive recordings to this incident, and we understand that. Ms. Martin and I have been doing public records cases for decades, and we're used to asking for stuff, not knowing whether it exists. This is kind of like that process to us. Our process has always been ask for the widest swath, and that way you'll get what you get. There was one of these proceedings in Mecklenburg County. The request was made for a particular type of particular incident, reporting of that incident, and unfortunately the Mecklenburg Police Department decided to take the most narrow view possible of that request and produced, my recollection is 2 minutes and 30 or 40 seconds of video, and it ended abruptly at the shooting of the person in a Burger King parking lot. Much to everyone's surprise, including Judge Bell, who was hearing the hearing, there was about another 11 or 12 minutes of video that had not been disclosed to the judge and had not been, certainly not disclosed in the process. That came about because it was shown to the city council in Mecklenburg County. Taking that information, that's why we make our requests as broad as we do. We're not trying to give anybody any hassle. We understand what the process is. We understand that it takes up the court's time. This is the process that our legislature has given us, and so we use it. We fully acknowledge Your Honor has an immense amount of discretion in what to do here, and we're always cognizant of that. In this particular incident, Mr. Brown, law enforcement went to Mr. Brown's house to serve what I understand are both arrest and search warrants. There was an incident, a shooting happened. Mr. Brown died soon thereafter, and it's my understanding that both Pasquotank and Dare County deputies were at the time of that incident, and then Perquimans deputies came in after the fact to both help with crime scene security and then both spontaneous gatherings at the location, and then it's my understanding at City Hall and the Sheriff's office parking lot. That's the gamut of what we're looking for. As I said at the beginning, we're not here to indict or vindicate anyone. We're trying to understand what happened. To suggest, as Mr. Williams has, and perhaps Mr. Womble have, that there's not a compelling public interest in this proceeding, the number of petitioners we have, the fact that you and I are probably appearing on television screens and computer screens all over the country at this point in time, and all that we've been through in the last year, is absolutely evident that there's a compelling public interest to release these videos. I have attached the 7 officer-involved shooting orders from other courts, and you will see in our index, it's a fairly short window most of the time when those recordings are released. Some of them within less than 2 weeks, some of them within about 2 weeks of the incident. Certainly, the ones that are at the beginning, it was unclear prior to having this statute whether recordings such as this were public records or personnel records or records of criminal investigation. The legislature has set us at least somewhat straight in that regard. They're not public records, but this is the process that everyone is given to seek their release. And it vests the court with the opportunity to review them and apply the factors that the court thinks is appropriate. As we've stated in the brief, and I'm assuming Your Honor has read the brief.
I have your brief and the attachments, and I have reviewed.
Okay, thank you. The radio traffic indicated that Mr. Brown had been shot in the back, which also adds interest in this under the circumstances. Mr. Womble's recitation of what happened, which stands in stark contrast with the family's attorney's representation of what happened, to me is absolutely compelling to release it. Everyone can have their opinion on what happened. The video may or may not show what happened or how it happened. And so releasing that will provide the information. The best vaccine to rumor is fact, and it shows the facts of what they are, or it may not. I have been, as I've said, I've done a number of these, and I've been in circumstances where somebody in an incident like this is claiming excessive force or something like that, police saying it didn't happen, and both results have happened. The video gets released and it supports the claims of excessive force, or it absolutely refutes the claims of excessive force. I have also had situations where it doesn't tell. It leaves it to be concluded. All of those things are important, as we state in our brief, that accountability is important, but in order to hold public officials accountable, one has to see what's going on, and this is very evident of that. I'm sure Your Honor is aware that in Minneapolis, in the George Floyd situation, that the original police report indicated that Mr. Floyd had a medical incident and that caused his death. If it weren't for the folks standing beside, I don't know if we would have ever known what happened in that case, and certainly Your Honor is aware of how that played out in the last month, well, even last week. That's the type of stuff that we as citizens, in trying to hold our public officials accountable, it's information. I have seen videos of officer-involved shootings. I remember one from Moore County. It was a hailstorm of bullets. It was very disturbing to watch. And I remember that it struck me again how difficult law enforcement's job is when a young deputy turned around and he was absolutely terrified of what had just happened. And it was important for me to see that and the public to see that, so they understand how difficult this job is. It's also important for law enforcement to see how their interactions with the public have an effect on people. It is part of that conversation. Your Honor, we do not believe that the release of these recordings will jeopardize an ongoing investigation or the pendency of any charges. There are none pending. Apparently there are active investigations. You will see in the orders that we've attached that these videos just like this have been released as investigations are ongoing. It's my understanding, and I know representatives of the SBI are here, that the director of the SBI has indicated that he's taking no position but certainly doesn't object to the release. If they're the investigating agency, I think that adds a lot of weight. And I hear Mr. Womble that you can use certain types of evidence to test the credibility of people. I've been around the block, you've been around the block. To believe that people involved in this situation aren't talking and haven't talked to one another and aren't comparing notes of what they think happened, it is just not accurate. It's what happens in these situations. It happened, I'm sure it happened immediately, as it's happened immediately in every one of these videos I've seen released. What happened, it literally starts right at the moment of the shooting and continues on. That's not going to change the facts. This was done in the open. Nobody had any expectation of privacy, be it the officers or Mr. Brown. And then, in addition to that, Mr. Womble has argued, and Mr. Williams has argued, that the names of the faces of the officers involved should be redacted. Certainly, that's within your purview, Your Honor. I know my clients have been asking for the information that is absolutely public record under 153A-98 with respect to the officers of the Pasquotank County Sheriff's Department. And so far that information has not been produced. And as Your Honor is aware, in our brief, we list that information. The names of these officers are going to come out because they have to give that public information. I don't want to be back here in a public records fight. There is no legal justification to withhold the information that the General Assembly has made public. If that information is out, then there's no reason to blur the faces of the officers. I am deeply disappointed, and I completely understand of threats being made, but the release hasn't been made, and there are already threats. I don't know how releasing it is going to change whatever somebody's motivation is to make additional threats or that sort of thing. And Mr. Womble, I believe it was, or maybe no, as Mr. Williams indicated, that somebody who didn't do anything wrong might be might be thrown into that pile of people that did. Well, releasing the video and seeing who did or didn't do what will work to alleviate that. Keeping it secret keeps the group of people unknown, and thus people are going to do what people are going to do. You experienced and you talked to us in chambers about the security. I'm looking around and there's security all around me. There was security. I couldn't even get parked near the courthouse. And if that's what needs to happen, that's what needs to happen. I know that you have security detail. I know that others do. And if that's what needs to happen, that's what needs to happen. With respect to the pretrial publicity, the court is well aware, and I'm sure you have access to the School of Government's bench book on pretrial publicity, and there's a whole host of things that a presiding judge can apply to deal with pretrial publicity other than sealing a particular record. I can't speak to the wisdom of what they did, but through this process, the General Assembly has made these recordings, which are now in possession of the court for in-camera review judicial records. And there's a well-established First Amendment right for access to judicial records. And any order sealing those records must be reviewed under strict scrutiny. And we don't think that such an order could withstand strict scrutiny.
But I'm not being asked to seal records. I'm being asked under the statute whether to disclose records.
And I get that nuance, Your Honor. What I'm getting at...
That's not a nuance. That's a pretty bright line exception or difference.
I understand that. What I'm getting at is the General Assembly has seen fit to put these records and make them judicial records. And thus there are First Amendment concerns that then attach to those records because they now are judicial records. And so by not releasing them, we think that's tantamount to a sealing order or perpetuating their being sealed. I don't mean to be pejorative in using the word nuance. I just think we have a difference of opinion, and I respect your understanding. The other aspect is the notion of delay. And if there's a First Amendment right to these recordings, that every day that they're not released harms that right, and it's irreparable. And so release, that weighs in favor of release. It appears, if I understand correctly, that the sheriff is in favor of release. The SBI doesn't take a position and doesn't object to it. The Brown family is in favor of release, and it's the district attorney and Mr. Williams and his unknown clients who are objecting to release. Our partner Hugh Stevens just finished an amicus briefing in a Supreme Court case here in North Carolina, and the name of it is not coming to me, but it involved an anonymous case filed in Cumberland County. Dovido. So there you go. Where we and others challenged the fact of proceeding anonymously. I don't think you can do that under North Carolina law. If Mr. Williams is making an appearance, he needs to identify his client for the court. Certainly I understand the practical reasons why he's not doing that, but I don't think he can do that under the Dovido case and comport with North Carolina law. If he identifies his clients, again, all of the reasons to blur and withhold the public records regarding the officers of the Pasquotank County Sheriff's Office fall away. And so I think that's important. There are no charges. Lastly, it is my understanding, and it's happened in the vast majority of these cases that I've done, is the recordings capture transmissions of law enforcement broadcast over the public airwaves. Under the public records law, that is unequivocally a public record, and it would take law enforcement coming to make a motion to have those not released, and they have to bear the burden of that. I don't believe any such motion has been made in response to our petition, and so I alert the court to 132-1.4C4. Your Honor, it wasn't argued here. I'll throw it so the court understands, because we may get there. I don't know the circumstances of what other first responders came to the scene. Others have argued that it would be in violation of HIPAA. And here, law enforcement, we provided you in a brief. Law enforcement are not covered entities. Their receipt of protected health care information in the discharge of their duties does not then lead to them In addition, as I've said, this happened in the public view, I believe, in public street. And so that there wouldn't be any HIPAA attachment, or that right of privacy isn't involved. Your Honor, as I started saying, the eyes of the world are upon us. And whatever these videos show, it will show them upon release. And people can draw the conclusions that they want to draw from there. I am not aware of any instance in North Carolina where the videos have been released, whether it's in an officer-involved shooting, a police chase resulting in a crash and a death, in a claim of excessive force, where a judge has determined after their release that a juror or a defendant couldn't get a fair trial, or and thus prohibited the district attorney from proceeding with the charges. I've not heard of a case where a court decides that the usual arsenal of things that a court has at its disposal to deal with pretrial publicity are ineffective because of the release of the videos. I don't say this because past experience doesn't necessarily predict the future, but I believe in these cases we've obtained release in all of them. There have been redactions and there have been blurring and things like that. One judge ordered the blurring of a minor child's face at a shooting scene. We've blurred people sitting in a booking area as somebody is being processed and that sort of stuff. What I urge you to consider if you are thinking about those things is that hard cuts on video lead to speculation. Minimal blurring to protect people who are truly uninvolved makes sense, and it doesn't lead to the speculation. We have also had situations where a witness is giving an officer somebody's cell phone number or other contact information, and we've muted those so that somebody's personal information isn't being given out. We're respectful of that. I think, not knowing what's on the video, I think you can craft an order that addresses those things but gives the public as much information as possible so that they can have a better understanding of what transpired here in Pasquotank County. Anything to add? With that, Your Honor, unless you have any questions.
No, sir. Thank you.
Thank you.
With regard to this petition, Mr. Womble.
And I'll be brief because I know Your Honor appreciates brevity. I just don't like being misquoted. And I stood up here and I did not say that there was not a public interest. I clearly said that public accountability was a public interest. I said that. In this case, it is outweighed by my responsibility to conduct the orderly administration of justice and also the potential rights of the accused or potential accused to a fair trial. It's outweighed. As counsel clearly stated, people will, his words, draw conclusions. That's what they're going to do. They're going to form and express opinions about what they've seen. And the video is the ultimate issue. This is not a tangential video. I don't know the ones that he's described. He's described the 30 or 20 odd times he's been around the state to obtain videos. I don't know what they show. I don't know that they go to the ultimate issue. I have no idea. In this case, they do. So, potential jurors in the first judicial district will draw conclusions according to his words. They will form and express those opinions. It will hinder the orderly administration of justice, and it will hinder a fair trial. Counsel pointed out that no case has ever decided that you couldn't get a fair trial. Well, maybe they weren't articulate attorneys. Maybe they held the trial somewhere where they don't have internet. I don't know. What I do know is that you cannot swing a skunk in front of a group of people and then ask them not to smell it. What I've asked is disclosure and release. I want Your Honor to give me an opportunity to complete this investigation, or the SBI to complete this investigation. Let me review it, make my decision, and then everybody can Monday morning quarterback me.
Thank you, Joe.
Mr. Williams, you have anything you want to add?
Yeah, sure. Maybe there's something I'm missing here, and I miss a lot of times.
Mr. Williams, I don't think you missed that much.
I'm reading the statute 132-1.4a, and in subsection C, it names the people who are subject to disclosure, to whom it may be disclosed. They include a person whose image or voice is in the recording, a personal representative of that person, a personal representative of a minor or an adult under lawful guardianship, a personal representative of a deceased person whose image or voice is in the recording, or a personal representative of an adult person who is incapacitated. And then you go to the section F, dealing with release. And it says, notwithstanding the provisions of subsection G, a person authorized to receive disclosure. The media is not a person authorized to receive disclosure. A person authorized to receive disclosure, and then going on, may petition the Superior Court for an order releasing the recording to a person authorized to receive disclosure. The court shall determine if the person to whom release of the recording is requested is a person authorized to receive disclosure pursuant to subsection C. I submit to Your Honor that the press does not have standing and is not covered by this statute. At the end, if in fact you order release with a delay of 30 days, then they can get it when it's released then. And we would ask you to deny the request, and then I would renew all of my prior arguments on the county's petition as well.
All right. Thank you, sir. Mr. High, I know that you were a party, your county was a party to this. Do you want to be heard with regard to this issue?
Just briefly, Your Honor, thank you very much, and good morning to you.
Good morning.
For the record, I'm Hackney High, and I'm here on behalf of the Clemens County Sheriff's Office. And as Your Honor well knows, that is a county that's located adjacent to this county, just west of us. Elizabeth City is not within the jurisdiction of the Clemens County Sheriff's Office, but shortly after the shooting, our office received a phone call requesting mutual aid assistance over here for crime scene preservation, for security, for crowd control, and the like. Due to certain budgetary constraints, we are a very small county, very poor county. We don't have body cams, and none of the officers that came to assist local law enforcement were equipped with body cams, and we don't have any recordings of any of the events that we witnessed while we were here providing that mutual aid assistance. I just want to be clear for the record, there is nothing that we could release because we don't have cameras and there were no recordings made. And accordingly, I would just ask that the Sheriff's Department of Clemens County be released from this proceeding and any further obligations that it may have.
You want to be heard with regard to that?
No objection, Your Honor.
Okay. I'll grant that relief.
Thank you, Your
Draw
Honor.
an order.
I appreciate it very much.
Yes,
Thank
sir.
you.
All right. Anything else?
Your Honor, just to address Mr. Williams' point, I want to make clear that the court is aware that the petitioners, my clients, the 20 media entities, have petitioned under 132-1.4 subsection G, which is the general release provisions. F is reserved for those entitled to disclosure and law enforcement. A major difference between F and G is those petitioning under F, which could be law enforcement or those entitled to disclosure, don't have to pay the $200 non-refundable fee. My clients paid the $200 non-refundable fee. Other than that, Your Honor, I would also say that with respect to speculation, the speculation and conclusions are going to be drawn whether or not they're released. We believe that release will will be, as I said, will quell the rumors or deal with rumors or vaccinate the rumors, because it will be facts that will be released. Thank you.
All right. Yes, sir. Yes, sir.
Your Honor, I want to clarify one thing. Mr. Williams waived notice today, and I want to tell the court that he has, of course, not seen this petition today, and I want to apologize to him because I don't think we were sure if this was under F or G, and I do understand in G, so to the extent I caused any confusion to Mr. Williams, I apologize to him publicly, and this has just happened at a very quick, fast pace. I think we're all learning a lot very quickly. As to the public records request, I've been inundated with public records requests, and I understand there'll be a time and place, and we do intend to address those, but I can't tell you how many I've received. So, again, sorry, Mr. Williams, and thank you, sir. Thank you.
All right. Well, certainly we're not here today on public record requests, so we'll reserve that for another day. All right. Anything else? Yes, ma'am.
Your Honor, Amanda. Martin, also for the petitioners with Mr. Toddy. As Your Honor knows, we served last night and have filed a petition asking the court to address the scope of the curfew that is embedded in the Elizabeth City declaration of a state of emergency. And as Your Honor suggested, I have spoken this morning with the city attorney. We have communicated about this, and I asked him if he was comfortable with me to put this on the record since he is not here, and he responded, absolutely, he is comfortable with this, that it's the position of the city that working journalists will not be subject to the curfew, and that he's not sure yet whether that will be through an amendment to the order or whether it will be through a working understanding and application of the existing order, but that he was comfortable with putting it on the court record that working journalists will not be subject to the curfew that is part of the existing.
All right. Well, that's absolutely something. There's nothing before me, an order or anything before me, so I don't think I need to comment on any of that. You can continue to work on it, and if y'all can reach a resolution, that's fine. If not, and we need to take action on your motion, then we can do so.
I don't think that will be necessary.
Okay. All right.
Thank you, Your Honor.
Thank you. All right, so here's what I'm going to do. I would like to be at ease for a few minutes. I'm going to go back in chambers and put these matters down and render my decision, and I'll be back out to do that in about 15 or 20 minutes, okay? And we'll be at ease until that time.
Your Honor, I don't mean to be presumptuous, but I did prepare with the caption for our petition the Form AOC order.
I'm happy to take that and look at it. Yes, sir.
Form basic, please.
Thank you. All right, anything else before we... All right, we'll be at ease for about 15, 20 minutes.
Thank you.
Court be at ease about 15 to 20 minutes.
All right, so they're gonna... It's gonna take a few minutes, as you just heard. So about 15, 20 minutes.
I'm gonna give y'all the copies. We're gonna post it Because the court is in recess, they should be ruling in about 20 minutes. All that was passed in 2016. That make him a lot more difficult. No, with that,
Whatever you want to say. I just need somebody to do it now. Right here. Because I don't want to lose my spot.
Yeah. Where you at?
Thank you.
All right, so what I'm going to do is I'm going to set up my microphone on the stand over here to get ready for the press conference. When they do come back, I will use my other mic to record the audio so you guys could listen in. But I'm going to set up the microphone now. Not yet. About 10 to 15 minutes. 10 to 15 minutes, they're going to come back and make a decision. Yeah. Yeah. Alright, mic check. Just turned on my mic on top of the camera. So the main takeaway from what you just heard was the district attorney, Andrew Womble, asked for a 30-day delay in releasing the footage. He claims that Brown was hitting officers with his car backing up and going forward. And it's really absurd that he argued that releasing the body cam footage would improperly sway jurors before the trial, which is kind of ridiculous. I don't know, hiding the footage. You know, what does that say? If you're trying to keep it hidden. So it's a ridiculous argument. Video in general provides transparency about everything, all details. I don't see how that would improperly sway a decision. So they'll be back in about 15 minutes to make a decision.
Oh, you want to show us?
Yeah.
Could you? Oh, okay. Glad to speak with you.
We get more and more leaders that
and then you copy about audio that you can to the president.
you want to keep us in the hours 6 to 8.
You be able to come on anytime?
Yeah.
Cool. Just a little update about the memberships. I know yesterday we were about 27, 25 members away from 1900, but now we're only 17 members away. So we could definitely get that by the end of the day today, or possibly by tomorrow. So let's do that. Let's you know, share the stream, tell your friends, tell your family to tune into Status Quo. I'm on the ground here in Elizabeth City, North Carolina. Just tell them to go to statusquo.com/join. It's only $5 a month. I have to go find a restroom before they come back. So give me a few minutes, I'll be back.
The menu, they adjusted it.
I wouldn't even know where to get them at that time.
He's a fashion photographer, beauty fashion photographer, and but at the same time, obviously as well. And it's not that they just, work. He's been doing this for years. So at one point, they came across his, I think it was Instagram or not sure. And then they had several he gets whatever he wants. I know somebody who was sponsored by someone. Disgusting. Like you really get like Sony just brought out a new camera, just like killing like they couldn't get A1.
Yeah.
Heard about it? I've heard of it. I mean, the body is 6,400 pounds.
So what is the
so what they did they got everything like the A7R4, the A7I, the A7S. They put everything together in one place. They really made it around the shoots 8K, you don't need 8K, but they shoot cinema. They shoot cinema. You have the example. It is. It's already I'm not much. You know how like when they get fixed wise at a certain point sort of well for top end video stuff. Yeah. You know, I'm gonna make an example like this camera is but he's an example. He's in yeah, for example, I mean, I almost kind of get whenever I see like the same subject everybody, so I'm always thinking about how we're going to the A-word well or what. Well, you do that consistently enough. Yeah, you know, there's not we didn't look at it for hard right now. It'll work out. Especially as they said, by major more authentic people here, because a lot of them
Can I ask?
Not really for media purposes. We're trying to get a count of people. We need 10 people here.
Can I get representatives of the media petitioners to come up here, please?
Just the people who are parties to this matter.
Gotcha.
Okay.
Daily.
I mean, you can go in. But what? Rob, you got it? Rob's got it.
Two more. Wavy TV's not in?
Wavy is in, yeah.
Come in. I think this is part of the media coalition.
Which is great media? Yes.
I don't know. I just wanted you to come up here so you were
9:10.
Wavy, well, Wavy just had to dump it. No. So here's 9, so I need one more.
It's up to you.
Okay, so you guys can come in. Understand? You gotta listen to what the rules are.
Okay, they're letting me in the courthouse if I go. Yeah, I'll just let you know. Yeah. Okay. Yeah. I'm just asking real quick. I want to take you real quick.
You did not.
Guys, to stay out. Okay.
You're coming in as a member of the coalition, you are not coming in simply as me. So the people, those are the only people who are allowed to remain.
Another person can go in my place if you like. Thank you.
Everybody good? And if we want to wait some people down here like you good? Feel like you're good?
These are their clients, parties to the petition.
The judge is waiting on us.
Everything changing and
Yeah, we're gonna march with the pastor. There's enough over here. We'll get the words.
Alright everyone, I'm back. So it looks like some reporters are going inside. You had to have signed the petition to get the footage released in order to go inside.
Too many here anyway.
Yeah, really good. Hey, nice to see you.
Now it's on. Can you hear me now?
yeah, no, they
So I'm guessing it won't be that much longer until they get back to deliberations. So let's or to make just a final decision.
I thought if there was the one guy standing right there, I would have
Yeah, you had to sign the petition to get the footage released.
He needs results.
Going on right now, a few blocks away at the church, I believe. There is a march with the community and the pastors.
Should we move back? Should we move back? Let's move back there. Actually, just stay there. I'll move up.
Okay, cool. Listen, they can all get it. Of course you can. Teamwork, right? Hey, how are you doing? Did you sleep okay last night?
So I don't know if you guys heard in the deliberations, but the sheriff, I believe Sheriff Wooten is actually in favor of releasing the body cam footage. So hopefully that has some. Hopefully that will help the decision to be made to release the footage.
Mic check 1 2. Mic check in here. Mic check. Make sure channel 2 is turned down. She said channel 1 isn't turned on.
Just because that's that much.
Mic check 1 2. Mic check, can you hear me? Mic check, can you hear me? Mic check. Mic check, can you hear me? Mic check.
Thanks for hanging in here, guys. Shouldn't be too much longer. Super chats are welcome. We greatly appreciate it. Everything helps to keep me out here reporting. There will be protests tonight. I believe there is another curfew in place for tonight around 8. So we'll see if what happened last night happens again tonight. We got about 4,000 people watching here, so let's hit that like button a little more. We got 1,000 likes. Let's get that up and share the stream. I noticed around the building over here, there's a couple of statues, but the one I passed, I could I'll try and show you guys. It was a Confederate statue. Let me see if I have the photo. Yeah, you're not gonna be able to see. I'll try and when this is over, I'll walk around there and show you guys.
Hey, lucky. Oh my god, yeah, like the perfect shape.
We finished. They're about to come in.
I told you.
Okay, what's the key number it says on the side? What it says? 61565.
1 2 1 2 1 2.
Well, Alexis, at the beginning of this hearing, they originally said that they were going to allow media into the courtroom, but after some further decision making, they decided to stream the proceeding online. And with that, they decided, we heard from a number of people, we heard from the district attorneys, we heard from some representatives representing the media, and from H.P. Williams helping the district attorney, he says that a number of reasons why they believe the body camera footage should not be released is one, the safety of these officers involved in the footage. He also believes that it will tamper. He also believes that it will tamper with the investigation. But as of now, we're getting some sound issues, so I'm going to turn it back to you, Alexis.
Just to I'll say it again, but so the district attorney Andrew Womble is asking for a 30-day delay in releasing the footage. His argument is that releasing the footage will improperly sway the juror's decision before the trial, which is absurd. And also he claimed that police arrived on scene and tried to open Andrew's passenger side door. And then Andrew had reversed and then went forward again, possibly hitting officers with his car, but those are claims we'll have to wait and see. That's why we need the footage. That's why the footage does not lie unless you're hiding it or redacting it, editing it. So there will be protests tonight. Again, I'm not sure if they're gonna close down the bridge that goes into Camden County. But yesterday, by shutting down the bridge, they created a traffic jam that went all the way to the Virginia, North Carolina state lines. I'm not sure of the distance, but That was pretty major. And then you saw the police show up in riot gear with threats of tear gas, pepper spray, rubber bullets. So what they did was they arrested 7 people, peacefully sitting. Well, 4 of them were sitting down in the street, not doing anything, had their hands up. They were actually singing. But the display from the police in riot gear was just absurd. Just kind of remind me of RoboCops. Yeah. In the front. Yeah. Oh, you were? Yeah. They didn't. Oh, I saw it because they created another line of officers not in riot gear for the people behind, right?
Because they were on media.
Right.
So they probably got better shots than anyone.
Yeah.
I was trying to shoot this from
Yeah, I get in their face.
Yeah.
I'm like, what are you guys doing? What are you guys here for?
I guess you really are allowed to. Because
Yeah.
you're moving out of the way when they need to.
What are you shooting for? Yeah? Nice. You have Twitter or Instagram? I'm John, by the way.
I mostly do everything on my website.
Yeah, it's okay. It's not a big deal.
This is just almost was a big deal. Things happened in the video, and then I got a call from like a platform. I signed up for last year and forgot that when they need it, and then all of a sudden I got a request because there's something to shoot. I'm gonna say right.
Do you have Twitter or?
I have my website. KillingLaw.com.
Oh yeah. Good mind to
Yeah, I didn't want to do that. When the 10 members, the front looking at both of me. That could have been bad.
And they don't take it down?
We've been, full reports, we've been advised the judge would like to stop broadcasting.
Is that like a small one?
No, this is the small one.
No, so they don't.
This is not the latest one.
Yeah, yeah, so, and then they're going to cut it.
I've never seen these before. I used to work in video like 15 years ago. I was doing it, the news, the finder came out to
Okay.
And then run with Amos. I wasn't.
One second.
It's okay.
Mike's trying to. Okay, so.
Yeah, right.
What about that one? Is that one good?
Hello, mic check, 1 2, mic check 1 2, mic check. Can you hear me?
We're listening to the press's opinion.
Channel 2. We don't have channel 1. I only have channel 2.
I never. That's weird. I never.
So she wants channel 1?
Yeah.
Never heard of that.
Mic check 1 2, mic check. Can you hear me? Mic check, mic check. Mic check, mic check, mic check. Can you hear me? Mic check, mic check. Mic check, mic check. Mic check, can you hear me? Mic check, mic check. Mic check. Just checking if you guys can hear me. Right now we're outside Aspen County Sheriff's Office.
down the key.
Did I ever tell you why that is? No.
You see, we're getting some new members. Very cool. Welcome to the community.
Well, Alexis, as of
Not sure how many we're away now. I think it's 16 now. 1900.
It would take some time, and right now all of the media companies are out here just waiting for his decision. Now, moments ago in their journalism proceedings, a number of attorneys spoke. Some petition attorney. We also heard from.
All right, let's get a couple more likes. I'm gonna tune into the stream in the courthouse. They should be coming back soon.
They should not release a video. He says safety of his officers. He doesn't think this release would keep them safe. He says they have already had a number of death threats from people without releasing this video, and he says it would make it worse. He also says that it would hinder some jury members' decisions when they do take this investigation to the court, and he goes on to list a number of more things, but from the side of the media, for the side of people pushing for the release of the video, they say that it's public knowledge. They say that people need to see the video and make their own conclusions. They also brought up a number of examples that have happened here in North Carolina, just like this one of Andrew Brown Jr., where the release of body camera footage has caused some issues. Now, he says in the case of George Floyd, in that case, he says that the release of the body camera footage, if people weren't there videotaping what happened, maybe that would have been swept under the rug. Now I'm going to play that footage for you guys to hear. Now we're all just sitting here patiently waiting to hear what the judge has decided. During the court proceedings, they said that they wanted the judge to see the video for himself to make his own prediction as to what effects it would make if that video has been released. They also discussed blocking out officers' faces and so on, deciding on whether to show more of the video, less of the video. And as we know, on Tuesday, the family only saw Andrew Brown only saw 20 seconds of that video. We don't know as of now if we will see the video in its entirety, or if we'll see 20 seconds, or if we'll see the video at all. As of now, we are just waiting to hear. Live in Elizabeth City, Sharon Dayquil for News Channel 12.
Which is really, I just want to today. And then,
Mike couldn't find it, but I'm going to rush back and see. Our car's just down the street. I'm going to rush back to the farm.
I'm here all week.
Just some unrelated news to this, but the feds just opened up an investigation into Rudy Giuliani.
Check with Adam with the dogs for Adam. Just like know how far they are or whether they ask for They've got to put down everything. He doesn't. I'm like, okay, that's still live. I'm like, all right.
All right, good news. Only 15 members away from 1900. All right, so let's get those 15. Help support the, my underground reporting here. Go to statuscrew.com/join and become a member. New York. In the city, yeah. Yeah, but I'm traveling all over. I just came back from Minneapolis from last week. No, I haven't been up there. Yeah.
I think that marched 2 years ago. Oh, that'd be good. Right now? Right now?
Maybe from here to the site.
All right, thank you.
So I just got some word about the march that started at the church. They're going to be heading this way. So I believe they're marching now. They should be here soon, possibly in time for the announcement of the decision.
Oh yeah, I take that. My
504. Yep, 504.
504. This is a long 20 minutes.
anything under $6-7. Oh yeah, operating expenses? Am I behind?
Oh, wait. You about to go live?
So I think they're going to be coming back in about 2 minutes. So I'm going to tune in there.
Rafi. The hands back, Sam.
All right. Sorry that took longer than I thought, but I wanted to be sure that I had it like I wanted it. All right. First of all, I want to thank everyone for your arguments and your work in this case. I say many times that it's always a pleasure. Court is always a pleasure when you have good lawyers. It just makes things better. And everyone who's before the court today did an excellent job and was prepared. So I appreciate that. So thank you very much for that. I'm going to begin with the 21 CVS 262, the media application release. recordings. The court, having reviewed the evidence, the petition, reviewed the brief filed by Mr. Toddy on behalf of his clients and all the attachments there too. The court is going to find that with regard to the media's request for release, that the media is not a party contemplated under 132-1.4G for release. But if they were, and it was appropriate to release to them, the court undertook the analysis under G with regard to the release of recordings and finds that there is evidence that the release would advance a compelling public interest. There is evidence that the recording contains information that is otherwise confidential or exempt from disclosure. Issues in a current potential court proceeding. The court finds, number 4, that it would reveal information regarding a person that is of a highly sensitive and personal nature. Number 5, that the release may harm the reputation or jeopardize the safety of a person. Number 6, that the release would create a serious threat to the fair, impartial, and orderly administration of justice. And number 7, that confidentiality is necessary at this point to protect an active internal and criminal investigation or potential internal and criminal investigation. The court therefore finds that that good cause does not exist for granting the petition of the media petitioners, and therefore that petition is respectfully denied by the court. That is my ruling. I'm going to prepare a order to that effect, and that will be prepared sometime this week, and I'll get that out to you in a formal written format at that time. All right. With regard to 21 CVS 261, the petition of the Pasquotank Sheriff's Department to release records to Khalil Farabee, who's the adult son of the deceased Mr. Brown. The court's going to find as follows, that this matter is properly before the court on the petition to release. To the extent that notice was required, notice was given by with Mr. Williams agreeing to hear the matter on behalf of his clients, but reserving his objection for lack of notice. The court has jurisdiction in this matter pursuant to GS 132-1.4A and all subparts. After hearing the arguments for the petition and the response from the district attorney for this judicial district and counsel for the respondents of all interested parties, the court finds as follows. Number 1, that the Pasquotank County Sheriff's Department is a custodial law enforcement agency, as that term is defined in the statute. Number 2, that Khalil Farabee is a personal representative under 132-1.4C4, and he's a proper person to whom the subject videos may be disclosed. The court considering the factors enumerated in subsection D of the statute. Number 4, that the court additionally considers the release of the video. In addition to disclosure, which the court finds is appropriate, I've also considered release under the statute. Using the same 8 criteria, the court finds that, number 1, the release is a compelling public interest. Number 2, that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. Number 3, the person requesting release is seeking to obtain evidence to determine legal issues in a current or potential court proceeding. But number 4, the court finds that release would reveal information regarding a person that is of a highly sensitive personal nature. The court finds, number 5, that the release may harm the reputation or jeopardize the safety of a person by release. Number 6, that the release at this time would create a serious threat to the fair, impartial, and orderly administration of justice. And number 7, confidentiality is necessary to protect either an active internal or criminal investigation or a potential internal or criminal investigation. Based on those findings, pending completion of the investigation and any decision regarding the prosecution of the potential defendant, the court orders as follows. That the 5 body camera videos be disclosed to Khalil Farabee and his immediate family within 1 degree of kinship, and one attorney licensed to practice law in the state of North Carolina. That is disclosure. That the video be held from release for a period of no less than 30 days and no more than 45 days. And that will allow completion of any investigation being undertaken by the SBI and by the District Attorney's Office in this county. Number 3, that the state is to notify the court when such investigation is completed, and the court in its discretion will consider at that time further release of the video based on the factors as they exist at that time. The disclosure of the video shall occur within 10 days, and the Pasquotank County Sheriff's Department is ordered to blur or redact all facial and identifying features of the officers shown prior to disclosure. That means facial features, name tags, any identifying information of those officers prior to disclosure. The court in its final order in this matter will specify the time frames within which the video may be disclosed. In viewing the video, there were certain portions of the video that were conversations between officers, between superiors. I'm going to evaluate those videos, determine which portions are appropriate for release and or for disclosure, I'm sorry. And then we'll provide that in my order so that the videos can be properly prepared to be disclosed to the family. All that to be accomplished within the next 10 days. All right, that's how I'm going to rule. Anyone have anything they want to add or ask with regard to clarification?
Your Honor, I believe there are 4 videos rather than 5.
I'm sorry, you're right, there are. There's 5 files, but there's 4 videos.
Okay, all right, thank you, Your Honor.
So I apologize, you're correct. All right, anything else?
Your Honor, while sitting here, I received an order from Ms. Hale regarding our request also into Elizabeth City Police Department. With your determination that my clients aren't entitled to seek release under subsection G, are you dismissing that additional portion of our petition as well?
Well, I didn't hear that portion of the petition, I don't believe.
Well, I guess what I'm getting at is, if we don't have standing, we wouldn't have standing for that. And
that would be my analysis. But I mean, I don't want to prejudge it because I didn't hear that portion.
All right, Your Honor.
All right.
Would Your Honor consider certifying your order for immediate appeal?
I'll take that under advisement.
Thank you.
All right. Yes, sir.
Will you be preparing that order as well, Your Honor?
Yes, sir, I will.
All right, thank you.
Your Honor, Major Wiley with the Sheriff's Office. I just want to clarify. It is 4 body cameras. One body camera does have 2 videos, so it's 5 body cameras and 1 in-car.
Copy. We are ready.
Okay.
2 minutes out.
All right.
Have them there for you.
Just so it's clear on
My
the
apologies. Okay,
All right.
thank you. Thank you.
And I will specify that in my order, and I'll clarify that with you before I enter the order.
Thank you, Judge.
All right. Is there anything else that we need to take up today in this matter? All right, again, thank you all for being here. If everyone would remain seated at this time,
That's what it was from the
we're going to
beginning,
adjourn court and give the officers the opportunity to do what they need to do before they can make sure that you folks all get out in an orderly fashion. All right? We'll be adjourned.
All right.
I've got Brian Todd ready for you, sir. So if the presser starts when I get a 2-minute, we'll walk.
All right, everyone. So you heard they're not gonna release the footage, but I believe they said they're gonna let the family see it. I'm not too sure about that. Clarify that.
On this story, he hasn't sent it out yet. Sean's writing it. But
Hey, so what was that? I couldn't really hear.
Okay. All right.
But there's some nuance I can explain on it. But bottom line, you're not seeing anything.
All right. So you heard it. They are not releasing the footage, but they will let the family see it. But the family cannot leak it to the public for 30 days. Yeah. Right, so only the family could see it, and one licensed attorney from North Carolina from here.
That's a jab. That's totally. Yeah, for sure. Well, from the beginning. And they have no choice but to trust. Even the road, backwards.
Right, so... All right, what I'm gonna do before everybody comes out, I'm gonna switch my microphone back to the mic that's on the stand to get ready for the press conference. So I'm gonna get tuned out for a little while. But yeah, this is absolutely absurd. So the court finds that the media lacks standing under the North Carolina Bodycam law. The court would have to decline public release of the footage on other grounds as well. The footage of Andrew Brown Jr.'s killing will not be released publicly. Judge denies media request to release body cam footage in the shooting death of Andrew Brown. Only Andrew Brown's son, will be allowed to view the redacted footage from 4 body cameras. And the judge is ordering that the officers involved faces be blurred. Again, this is absolutely ridiculous, because if they have nothing to hide, then they would show everything. If they're justifying this, okay, I'm going to switch it over.
When did they let you guys inside?
What's that?
When did they let you guys inside?
Oh, well, the judge was deliberating.
Got it.
So we only saw the last season. Did you guys get any of that?
Sorry?
Did you guys get all that? Did you hear what happened?
Give me a taste.
Well, we made disclose it recently on the same day. Spread out all the different cases and the gameplays and possibly some of the problems. We're not going to release it at all. Release the money.
Oh, he's over there.
Your choice. Your choice. Good work. Good work. It's still coming out. It's always working. Return is still inside. Return is still inside. That's all I gotta say about it.
What's your name and relation to?
That's my cousin.
Okay, what's your first name?
Elisha.
Can you spell for me?
Elisha.
Okay, and your last name?
Dillard. Dillard.
Okay, and your Brown's cousin?
Yep.
So what? So you're happy then once again, encourage that the family will be able to see these body cam.
I'm quite sure. Yes.
Okay.
I can't wait.
Okay.
I won't know.
Can you spell your last name again, please?
Dillard.
V as in Victor, Illard.
Yeah.
Elisha Bennett.
Right.
Right. Thank you.
Elijah, for everyone who just joined in right now, your initial reaction to the judge's ruling?
I think it was a, guess you could say a just ruling. Other than that, we got to go with what he said. That's all we can do.
You're calling it a just ruling?
Thank you.
Yep. That's it.
What do you think
about the judge ordering that the
Ma'am, did you want to come this way?
Oh,
Can we get your reaction to what happened?
I guess he's doing that for their safety. I mean, other than that, you know, I remember what they could have showed it. We're going to eventually know who they are. You know what I'm saying? So they could have showed it.
That's how he will speak to us.
And this is my oldest
his
brother.
side of the story.
Yep.
What are your thoughts on what the district attorney said inside the court, arguing that Brown's car made contact with some of the officers?
First time today, and that was a week ago?
Yep.
No,
First time we heard it.
not buying it.
Nope.
But thank you.
Can I get your first and last name?
Lily.
Spell for me, please, Lily.
Lillie.
And your last name?
Double name, Brown Clark. No E.
And your relation to Mr. Brown?
Aunt.
Your
And your name,
aunt.
sir?
Thank you very, very much.
Elisha.
Can you spell that?
Elisha.
Elijah.
Dillard. Dillard.
And Elijah, that was the first time that you heard anything like that Brown made contact with the officers with his vehicle.
Yeah, that's what I heard. I mean, you know, if they was there, he's backing up, then going forward, they had the car surrounded. So that's telling me why didn't y'all, you know, just open the door and tell them to get out and lay down? But they just, you know, he said they backed up and hit him and then went forward and hit him. The first time I heard it today.
But do you think what the authorities will then argue going forward is that gave them a reason, a justified reason to shoot?
Shoot on our man? No. I don't think they wasn't justified to shoot on our man. He had his hands on the steering wheel. I mean, you know what I'm saying? They had the advantage. To me, anyway. So, no. And I thank y'all, huh?
Had you hoped to see the video sooner, that it would be quicker?
Well, I mean, I would love to see it today. Thank y'all.
Elijah, what's your relation to?
He's my cousin.
I do think there's a misapprehension of the statute. If folks thought we were moving under subsection F, which would be worse. The box is clearly checked for subsection G, but we'll certainly visit that issue. With respect to the issue regarding release, it's certainly within his discretion. We're disappointed about that. We still believe that release would be appropriate and perhaps even helpful in this case. But at the end of the day, the judge is afforded an enormous amount of discretion under the statute. We'll have to deal with the standing issue, which, as I've indicated, I think this is my 34th or 35th one of these, and that's never come up before.
Do you believe the family will release the videos to the media?
I have not talked to the family. I don't know.
Do you have recourse now?
Well, once the order is entered, as you probably heard me asked if he would consider certifying it for immediate appeal. The reason that I asked that and the other question, we also made a request. It's the same petition that we're here under, sought the recordings from Elizabeth City Police Department. And what I was referencing is that while we were in the hearing, I received an order saying that the Elizabeth City Police Department petition wouldn't be heard today. If our clients don't have standing, then there's no need to go forward with that hearing, in my mind, being consistent with his ruling. But immediate appeal, you can't appeal something that isn't finished. And so if we have to come back here for the Elizabeth City PD, then so be it, and we'll appeal when we can.
You said you worked on a lot of other cases like this, and this one appears to be handled differently. I mean, why do you think that is?
I have no idea. I understand that our clients, the media, are not entitled to disclosure under the law. They don't have a right to come and say we want to see the recording at the sheriff's office, and that's why we moved under G, which is listed as general, and so this is didn't see it coming. Not sure how it got there, and we'll certainly assess it when we can.
Toddy, why does North Carolina treat police video as judicial records rather than public records?
Well, that's my argument. What I was saying was that before, when we would seek body cameras or dash cameras, there was more dash cameras at the time, it was unclear. Were they public records? Were they records of criminal investigation? Or were they personnel records? And when this statute came out, it made clear that they were neither personnel records nor were they public records. And so through the process, the General Assembly, in my opinion, by having the court order them into the court, make them judicial records. And as I said in my argument, I think our clients, through the First Amendment, have a right to those records.
Mr. Toddy, you brought up the case of the Aquarius Franklin, March 2019 in Charlotte. How is that case similar to this? What overall point were you trying to make there?
Are you talking about at the Burger King?
Correct.
What I was getting at was, in that particular case, the request was made for the recordings of that particular incident. What happened was recordings were produced to the court for in-camera review, and they were released. And then sometime later, my recollection is the Charlotte City Council watched those recordings and many more that had not been disclosed to the court, that were in existence but unknown to the court. And so that's why our requests are broader than perhaps most, because we don't want that to happen again. This is an inefficient process, and we want the court to decide it and move on, as opposed to the piecemeal, we didn't know it existed. We can appeal. The judge has an enormous amount of discretion on his substantive ruling on release. The issue that I didn't see coming was, do we have procedural standing? Do our clients, under the general provision, have the right to be here and petition? What I understood Judge Foster to say was, no, we don't. Which means, if you carry that further, that no one in North Carolina does. The media aren't special, and we aren't trying to say that they're special. If my neighbor is in a situation and I am not doing it on behalf of the media, I think under subsection G, I should be able to make a petition to ask for the recordings to be released.
When disclosure is made to the family in 10 days, will they be able to take notes accordingly? What will they be able to do?
The judge can limit what happens at those things, and it sounded like he was planning on not only limiting what they would see, but who could see it and what could happen there. I will freely say I've never made a petition under F because I'm not usually representing the people in the video. I'm representing you guys.
What's the disclosures made to the son and the other lawyer? Do they have the power, the authority to release it to the public?
So
Clarify disclosure.
that's what, yeah. It's really important for you guys to get this right. There is disclosure under the statute and there's release under the statute. Disclosure means you can see it. You cannot have a copy of it. Release is you can have a copy of it. The county's petition and our petition were seeking release. What I heard the judge say with respect to the other petition, he was granting limited disclosure based on his parameters, and then 30 to 45 days later, release. That's when somebody can have a copy. the statute indicates that the judge can limit, restrict, condition any release. And so I don't know what, we'll all see what the judge does in that order, whether he conditions it, should it be released.
Now, when you say total of all 6 files, all 5 files,
No, we don't know anything about that. The way this statute works is we file the petition, well, worked until today. We filed the petition, the court issues an order to law enforcement ordering them to put the recordings into the court for in-camera or in-chambers review, sets the date and time of a hearing, and law enforcement is to give notice to law enforcement officers in the recordings, whether by image or voice, that they have the right to be at this hearing. That was Mr. Williams' position. He was representing those folks. We don't get any copy of the notice that went out to the people. Most often we don't know who's in the video until it's released, or whose videos they are until they're released.
Now, when the judge said 30 to 45 days, is that starting today when he signs the order, or is that starting from when the family gets to see it?
I don't know. We'd have to read what the order that gets entered says.
What would you say to the residents who feel this is
I don't know what it is. I don't understand the standing issue at all. I didn't see it coming. Nobody's ever raised it before, and I think it's a misunderstanding of the statute. That's what I'm hoping it is. That's why we have courts of appeals in Raleigh, and if that's what we need to do and our clients want us to do, that's what we'll pursue.
Mike, is this the first time this judge has made a decision?
I don't know that. I don't know his familiarity with the law at all.
I just want to take a second to put in plain English this issue about standing, because that's. I just want to put in plain English this issue about standing that you asked about. When we, as lawyers, talk about standing, the question is, do we have a right to even be heard? Do we have a right to come in here and say, we would like to get copies of these videos? In our view, that part is not discretionary. The statute is very specific, and we believe it spells out that we do have a right at least to ask. We concede that the judge has great discretion in deciding whether to release, but essentially what the judge said is we didn't even have the right to ask, and that's where we think that he's incorrect in the reading of the statute.
Thank you all for your time. Thanks to our clients for pushing on this. You'll hear from us soon enough. Thank you.
Hello, everyone. I'm Wayne Kendall, and this is Mr. Harry Daniels. We represent, along with Ms. Lassiter, the family of Andrew Brown. You guys have probably heard what the judge decided today. I would consider it somewhat of a partial victory for the family, in the sense that the judge did order a redacted release, or not, excuse me, I need to be clear about release and disclosure. He ordered a partial disclosure of the video camera recordings to the son of Andrew Brown, Mr. Khalil Farabee. And that is to occur sometime within the next 10 days or so. That release should be made, and then he's also ordered that disclosure should be made, rather. And then within the next 30 to 45 days, he will decide whether or not there will be an actual release of the video recordings to Mr. Farabee, depending upon whether the district attorney decides to bring any criminal charges or not bring criminal charges. We consider that a partial victory in the sense that the judge and the district attorney and the sheriff's department have admitted that there are at least 4 recordings and 1 dash cam recordings for a total of 5 video cameras. As you will recall, a couple of days ago, they released only a snippet, a 20-second snippet of 1 recording. So at least now, in sometime within the next 10 days or so, we will have the opportunity, or at least one representative of the legal team, as well as Mr. Farabee, will be allowed to see these, what we consider to be now 5 video cams in full with only the facial features of the deputies that were there on the scene, as well as their identification like a name badge, to be redacted or blurred out. So from the standpoint of the family, we would consider this a partial victory. Now, I also want to address something that I heard the district attorney to say that greatly disturbed me.
Greatly.
And that was the fact that Ms. Lassiter here, who is standing to my left, somehow misconstrued, misrepresented the contents of the 20-second snippet that she was allowed to see along with a couple of family members a couple of days ago. The reason that greatly disturbs me is because this district attorney has had access to these recordings since they were recorded. The full recordings, all 5 video recordings. He has had full access, and had he allowed Ms. Lassiter to see the entire contents of all 5 videos, there wouldn't be any issue about what's on the video and what his description of what is on the video is versus what her description of what the video is. And further, if he had released those video recordings to all of you, then the entire world would know what's on those videos. So for him to come into court today and suggest that she somehow misconstrued or mischaracterized what is on those videos when he only allowed her to see 20 seconds of one video cam is beyond reprehensible.
He should be admonished for it. He should be admonished.
The governor, Roy Cooper, you have called for a special prosecutor. There is no better reason than to have a special prosecutor in this case than what we heard Mr. Womble state in court today. He would take it upon himself to call for an admonishment of a licensed member of the bar for giving an honest interpretation of what was on those videos, that small snippet that she was allowed to see, and to ask for her to be admonished by the court for giving her recitation, her honest recitation, as a member of the bar of this state, as to what she saw. It's beyond reprehensible. When he has it in his power to let the whole world see all 5 videos. Now I'm going to let my co-counsel, Harry Daniels, make a statement as well.
Let's not get distracted. An innocent man was gunned down, shot in the back of the head, vehicle riddled with bullets from the rear. Now I heard statements being made, well, he might have hit the deputies, or he might have did that. Well, show us the video. Show us the video. Show us the tape. Show the tape. If that's your position, show the tape. We already know if that was the case, then the media attorneys would not have to make an argument to show the tape. The tape will already be shown. If that exonerate the law enforcement officer, the media would have already seen the tape. In Columbus, Ohio, the tapes was immediately shown. Immediately shown. Show the tapes. Now, Ms. Lassiter here did an outstanding job. She went in that room, she came out, and what she saw on that video is what she saw, and she represented. I've known her for a long time. A long time. And one thing I can tell you, she is not known to tell lies. She is very professional. And for this district attorney, the elected official, to take a poke or stab at her character when he had the opportunity to review all the evidence, and she saw a 20-second snippet, and she stand by her position that Andrew Brown was executed. Let no mistake about it. She stand by her position. It is appalling. It's shameful and it's disgraceful. But I assure you this, justice will be had. Justice will be served. In 10 days, 30 days, 300 days, or 3 years, justice will be had. Now, Chantel, I'm gonna let you come. You want anything to say?
Hey, I think I need to say a couple things. Good afternoon.
Good afternoon.
Hey. A couple days ago, Bacardi Sellers told you guys how he felt disrespected as a black man. I have felt that same disrespect today. I am a member of this district, District 1 bar member in Elizabeth City, North Carolina, and I was not given the professional courtesy by Andrew Womble to have a conversation. I would have been glad to have a conversation if there was any confusions or questions about what I saw. I would have been glad to have a conversation, but he did not give me the opportunity.
He knew your phone number, didn't he?
He has my information is all out there. And
you said you know why?
Time,
I'm asking him, do you know why?
You should ask him
ask
that.
him. I have
ask
no
him
idea.
that. Don't ask him why.
At no time have I given any misrepresentations. I have still stand by what I saw in that clip it. I told everyone what I saw. We had 20 seconds. We watched it over and over to ensure that I tried as best I could not to miss anything.
And that's the whole reason. If you have a disputed facts, show the tape.
Right.
That's the issue.
And also, again, it was only one. We only saw one body cam. So if it's 5, I didn't even see 20 seconds of those 5. I only saw 20 seconds of one. So if I missed anything, and then with the redactions, it was a lot of blurred visions. So. Again, I stand by what I saw, and we will watch it again with the family again, and, I just feel disrespected. So thank you.
All right, I'm going to limit it to about 3-4 questions. So,
Mr. Daniels, have you been in contact with the FBI since they joined?
No, I have not been in contact with the FBI, but the FBI is here to investigate this matter.
Ms. Lassiter addressed just at any point in the video that you saw, does Mr. Brown's car go towards the deputies or hit the deputies?
No, in no portion that I saw, he was backing out away from the deputies.
No.
And in prior video, and before when DA Womble had the meeting with you, did he give any indication before in the court hearing that that was the case, that the car had been moving forward and he had told you before, or is this the first time you're learning about it?
Absolutely not, and I answered specifically, what do we have here? And he disclosed nothing. He playing politics here. He's still running for judge, you got to remember.
And just to follow up, and if that is the case eventually, whether one way or another, does that change anything in terms of...
We will assess all in evidence that we have. Right now, my position is what Ms. Lassiter stated, and I have a man that's dead, 7 children, shot in the back of the head, guns riddled in the back of a car. So regardless, show us the tape, and we'll determine what's justified, what's not justified. Right now, it is on their hands. It is on the hands of the Pasquotank County government. Show the tape. Any more questions? All right, we're done. Let's go.
Mr. Daniel, has the family filed any lawsuits against the city of Elizabeth yet?
Give me a second, everyone. I just have to get my microphone. I'll try and interview a few people here.
Thank you. That's not mine.
So, you just heard the judge's ruling. The judge is basically sitting on this one for the next minimum 15 days, maybe as long as 30 days. Maybe it's disperse. There's no tapes that have been released yet. And we're waiting to see what happens.
You might check the
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
So there's no further, nothing's happening. It's an absolute shaky sport. It's not been released yet. They should be releasing the tapes.
Not violates the administration of justice. We can't have a free and open society unless we have disclosure of the action of officials. What they do in our name is important. What they do in our name that we don't know about is detrimental to the operation of a free society.
Was today the first time you heard about two or officers being hit by the car?
Never has anyone ever said that Andrew Brown in any way threatened these officers. And believe you me, that had he threatened these officers, this video would have been out the next day. Would have been out in droves the next day. You guys would have been the first to know that this shooting was a justified shooting based strictly and solely upon the fact that Andrew Brown threatened these officers with a vehicle. That didn't happen. You can go out there and look at the ground and see the tire tracks on the ground, and they go in reverse. All the witnesses that witnessed this incident said that he went in reverse, and they started shooting before he even started the vehicle.
If it is established that the car somehow did strike these officers, does that necessarily exonerate the officers?
Absolutely
criminally?
not. Absolutely not.
Why not?
Because these officers would have had to have had a reasonable expectation that Andrew Brown was a threat to them in that vehicle. I don't think that there's going to be any facts to show that Andrew Brown was a threat to those officers in that vehicle. None whatsoever. If the facts show that they were holding on to the vehicle or whatever, and he was just simply trying to avoid contact and get away, and they placed themselves voluntarily in some manner to be harmed, then you may have an arguable case. But I don't think there was ever an intent, and no one will ever be able to show an intent, and no one will be able to show that there was a reasonable apprehension of an intent on the part of Andrew Brown to harm these officers.
Mr. Kendall, are you from North Carolina as well?
No, from another. Absolutely not.
And so,
No.
Mr. Kendall, so are you worried that there may potentially be some sort of cover-up, the fact that there is this delay? They're saying that he was aiming for officers, but we're not being allowed to see that?
I think there's a cover-up of the cover-up.
Thank you, Mr. Kendall.
And what do you mean by that, sir?
Well, there are layers of cover-up. There are people that initiated this, that know what happened, that are on the scene, that are actively providing cover for the people who went out and performed the acts. So when the higher-ups cover up for the people that did the acts, and the people that did the acts are trying to elude accountability, that's what I call a cover-up of the cover-up.
And do you think that there will be accountability? Are you hopeful for that?
There will definitely be accountability in the end. It's just that, it's going to be a fight because they're trying to not disclose information as best they can.
And Mr. Kendall, you call this a partial victory for the family, but the 7 days ongoing of protests here, the public has been wanting this video. How frustrating is this for the public or the protesters, the people who have to wait and then have to wait for another judge's order on this case?
Well, I say it's a partial victory for the family because this judge, for the first time, has indicated that the family will be allowed to see all videos with only redactions of identifying information, facial information, badge information, that sort of thing. So we've only, to this point, been allowed to see 20-second snippet of one recording. So that's a partial victory in that now we have 5 video cameras, dash cam, and 4 video body-worn cameras. So that's why I say it's a partial victory.
But for the
true-
public, for the other people who are waiting on this that don't have that access right now, how frustrating is that for them?
Very much so. And I would like for the public to have that access. I just don't represent the public in that sense. I represent the family. So to the extent that the public is not allowed to see it, there is no victory. And we heard from the representative from the press who says that this judge basically says, and I'll paraphrase, this judge is entirely off base to say that the media does not have standing. Now, I'm not a First Amendment lawyer in North Carolina. I'm not super familiar with this particular law in North Carolina. But according to this man, Michael, who was here representing the Georgia Press Association and all 20-plus media organizations, he says that the judge is off base to say that he does not have standing to ask for a release of this recording. Now, I have to take him at his word. I mean, he said in the hearing that he's done 30 to 33 hard filings of this type to get recordings. So I'm assuming that he knows what he's talking about.
How soon do you think Khalil will get to see it? Did you get
Well,
any
the
sense of, like, today or tomorrow?
the judge said 10 days.
Yeah, but I mean, I didn't know if he gave you a sense. We'll get it to you quick, like tomorrow.
I don't think it'll be that quick. The judge has to formally write up an order. That may take a few days. And then he's also indicated that there's some redactions that need to be made that he's going to want to probably review. So I don't know. And then there's 5 cameras, so I don't know how long that's going to take. But he said within the next 10 days.
Well, what do you think about the judge's order? It's an unusual order to blur the faces of the officers. What are your thoughts about that?
Well, I have to rely on what the media representative said. He said that under North Carolina law, and I'm not familiar with this, I'm just paraphrasing what he said. He said under North Carolina law, there is the ability to get the names of the individuals who carried out this act. And he named the statute, and I wrote some notes down. He named that there was a statute, and if that is in fact the case, then there's no point in blurring faces or identification, because if the public has a right to the names under some personnel law, apparently, then there's no point in blurring the faces. And I will say this too, according to Ms. Lassiter, not only did they blur the faces in the 20-second snippet that she saw, but they also blurred body parts and weapons. So that 20-second snippet that she saw was basically almost nothing. I mean, when you consider the fact that they have 5 times as many recordings, 5 instead of 1, and they were blurring weapons, so it's highly possible that she did not see what could have been seen if there was a contact with an officer in that vehicle. And that's why it was so unfair for this district attorney to imply that she mischaracterized a video that he was apparently a part of and objected to having the family to see.
Jordan Wilkie with Carolina Public Press. In order to counter the statements from Womble, attorney last year said that she had several pages of notes. Are y'all interested in releasing those notes or any version of them to show the entire scope of what she was able to see?
You'd have to ask Ms. Lassiter that, but I would kind of doubt it. That's attorney work product, which is privileged. Thank you, guys. I appreciate it.
Thank you. All right. What's that? Yeah, it smells like cover up.
It is a total.
Yeah.
I mean, seriously, why would 2 cops quit and another take early retirement if it wasn't a country?
Right, yeah.
Seems pretty glaring.
Say again?
I said it seems pretty glaring.
Oh, I thought you were talking about my scalp. That's just shea butter, brother. That's shea butter, vegan diet, and filtered water, man. That's what that is.
Joe, this is Ron, Joe.
How you doing? You good? Yeah, going up Brazil. Tipo brasileiro.
Yeah. Let me go see if I can talk to some people. I'll come back. I'll be back here with you guys. How are you? You too.
Yo, I remember you from Fort Monroe. Yeah, man, how you doing? You good?
Small world, right?
Yeah, it's very small.
All right, so not many people out here, mostly press, reporters. I'm going to go get some rest because I know I'll be back out here for the protest later. There was a march. I'm not sure where they are now, but all right, let me just check the feed here. All right, we're 15 minutes away, 15 members away from 1900. So let's get those memberships up. Let's get to 1900 by the end of today or tomorrow. So really push this out there. Push out these interviews. Let people know that they are basically covering this up. It's pretty obvious. They're hiding whatever it is, this execution. Hey, Rosa. All right, everyone. I'm gonna sign off here, go get some food, get a drink, and I will be back later. Not sure what time, but you could text COUP to 370-370, and this way you'll get the notifications when I do go live again. All right, take care. I'll see you later. Or you'll see me later. All right.